Hi, good evening. Uh, this is the Bombay High Court judgment in the case of Dodal Electro Instruments versus Micro and Small Enterprises Facilitation Council. Facts of the case: Maxim is a private limited company. It is engaged in the business of rubber and plastic products. Dodal is a proprietorship concern. It is engaged in the business of electrical products. So Dodal used to purchase the material from Maxim and use it in their products. Dodal purchased materials by placing two work orders. There must, there must have been some dispute with regard to the payment. The, the principal amount due by Dodal to Maxim was, in one work order it was 1,47,000, and in another work order it was only 3 lakhs. This is very important. The principal amount due under work order is 1.47 lakhs, and in another work order it is 3 lakhs. Then, since the payment was not coming from Dodal, Maxim approached the Facilitation Council. The Facilitation Council, then they examined the facts, they issued the notice. Dodal did not appear. So FC ordered payment of principal amount of 1.47 lakhs along with interest of rupees 27 lakhs. Kindly note, interest amount is 27 lakhs, principal amount was only 1.47 lakhs. Another work order, principal amount was 3 lakhs, interest amount was 39 lakhs. So FC ordered, because they did not appear, you pay the amount. That is the order. Dodal challenged this order by way of a writ petition before the Bombay High Court. So the issue before the Bombay High Court was whether the writ petition is maintainable before the High Court, because there is an appeal provision under the MSMED Act. So they should have availed the alternative remedy, which is effective and efficacious. So they should not have filed the writ petition. That was the contention by Maxim. Bombay High Court said that entertaining a writ petition or not, in spite of the alternative remedy available, that is a self-imposed restriction on the exercise of writ jurisdiction. The rule of exhaustion of statutory remedy, it is a rule of policy, convenience and discretion. Whether availability of alternative remedy is an absolute bar on the exercise of writ power of High Court, even in exceptional and rare cases, that is now under consideration before a constitution bench of Supreme Court. So, is it if there is an alternative remedy, will it be an absolute bar on the exercise of writ jurisdiction of the High Court? Now that is pending before the constitution bench. Then the court said the mere fact that it is pending before the constitutional bench, it will not eradicate the law laid down by the Supreme Court. Earlier law, presidential value, cannot be diluted just because it is pending before a constitutional bench. The court looked into see whether exceptional circumstances existed in this case for the exercise of discretionary power, because they have an alternative remedy. There is an appeal. Now the first ground Dodal was principles of natural justice is violated. I have not received the notice. That was the first ground. Court perused the records and then said no, notices were properly issued. So that ground, it said it is not a valid ground. Then the second ground was that the Maxim is not a small scale industry as per the MSMED Act 2006. So it was not registered by filing the memorandum. That was the contention. That was also rejected. The third contention was the Facilitation Council clubbed the conciliation and arbitration proceedings which is against the mandate of statutory provisions. I repeat, the Facilitation Council clubbed the conciliation and arbitration proceedings, which is not as per the statutory provisions. That was the third contention. Then, for answering this question, court looked into section 18(2), 3 and 4 of MSMED Act. There is a two-stage mechanism devised by the Parliament under the MSMED Act. The first stage is if there is a dispute between parties, then Facilitation Council must try to solve the issue by conciliation. Then, in case if the conciliation fails or the conciliation proceedings are terminated, then stage 2 will come into play. That is, arbitration has to be initiated. Facilitation Council either it can arbitrate or it can refer the matter for arbitration. So, both the options are available. So, two stages. First, conciliation. Second is arbitration. Section 18(3) is in contrast to the fundamental principle of arbitration. Because the fundamental principle of arbitration is party autonomy. Party they will sign, we agreed, we go for arbitration to refer the disputes. This will be the jurisdiction, this will be the seat, this will be the venue, and we will be bound by the judgment of the arbitration, etc. It is a party decision. Parties, they independently they take a decision. But under section 18(3), when it comes to MSMED Act, it is a kind of compulsory arbitration without consent of the parties. Parliament provided that not only the provisions of the Arbitration and Conciliation Act will apply, but also it would apply as if the arbitration is in pursuance to an arbitration agreement. That is, whether there is an agreement, arbitration agreement or not, it will be deemed to be there. That is what the Parliament says. Bombay High Court said to decide the question, this question, the pivotal issue is whether Facilitation Council decided to proceed to arbitration, and if so, whether the proceedings were conducted in conformity with the ANC Act. Because the contention of the Dodal was that both are clubbed. This conciliation and arbitration is clubbed. So Bombay High Court wanted to see whether really the matter was referred to arbitration. Stage 2 has reached, and the proceedings are conducted in pursuance to the arbitration proceedings provisions. Bombay High Court noted down the following facts. 1. Facilitation Council decided to initiate conciliation proceedings between the parties because there is a dispute. So they decided to initiate conciliation. 2. Dodal failed to appear for the notices issued by the Facilitation Council. That is also a fact. From the record, it found that Dodal did not appear. 3. The impugned order of Facilitation Council did not indicate that conciliation proceedings failed or they terminated. It is silent on that aspect. 4th, the impugned order is silent on whether FC proceeded to arbitrate the matter either by itself or refer the parties to arbitration. That is another point which was noted. Then 6, parties were not called upon to file statement of claim. Okay, you file your claim, you file your claim. Nothing was asked. 7, the order of the Facilitation Council stating that the claim of Maxim appears to be genuine and there was default on the part of the Dodal does not clothe the order in the nature of an arbitral award. That is the one. The final one is none of the provisions of the ANC Act, Arbitration and Conciliation Act, was referred to in the order. So all these facts were noted down by the Bombay High Court. Bombay High Court held that orders passed in breach of mandatory provisions of MSMED Act and ANC Act is fit to be interfered with. That was the question. Because there is an alternative remedy, Bombay High Court should not interfere. Now Bombay High Court says, because the order is passed in breach of the mandatory provision, it is fit to be interfered with by exercising the writ jurisdiction. Failure to adopt express statutory provisions in conformity with which only the decisions were required to be rendered, furnishes a surer foundation for exercise of writ jurisdiction. Bombay High Court said, if you don't adopt the mandatory statutory provisions, and if it is floated, then it gives a definitely it is a foundation for exercise of writ jurisdiction. That is what the Bombay High Court said. So Bombay High Court remitted back the matter to the Facilitation Council. Again, you uh, follow the proper procedure. That was the order. My comments. I am sorry to say, penny wise and pound foolish. That is one English saying. I think that will apply in this case, subject to other facts. Because from the judgment, I don't find anything which supports Dodal. That is why I say penny wise and pound foolish. Principal amount is meager, 1 lakh and rupees 3 lakhs. In one order, it is 1 lakh, another order, it is 3 lakh. Interest amount claimed is and awarded is 27 lakhs and 39 lakhs. Astronomical interest, because 18% interest, assuming 6% is the bank interest. So, three times of bank interest comes to 18%. So, it is coming to interest amount calculated comes to 27 lakhs and 39 lakhs. So, there is nothing which I am able to see from the judgment that the claim is incorrect or wrong or the product was not all right. Nothing is there in the maybe it is there. I'm not. It is not mentioned in the order, the Bombay High Court order. Hence, even this, even assuming they won the case, Total won the case because the court said I am remitting the matter back to the Facilitation Council. But it is of what use? It will be further detrimental to the business interest of Dodal because the principal amount is going to remain the same, 1.47 lakhs and 3 lakhs. Interest, if it has been correctly calculated, that 27 lakhs may become 35 lakhs and 39 lakhs may become 45 lakhs or something. So it is definitely detrimental to the business interest of the Dodal. And Dodal is a proprietorship concern. So that is point number one. Point number two, in case of dispute between MSME, this is my suggestion to the business people. Whoever it is, you may be a bigger fellow, you may be a smaller fellow, you may be a medium fellow. But if you are entering into dispute with MSME, then the dispute has to be seen unbiasedly. Your ego should go to the back seat. Uh, because MSME is armed with the MSMED Act. The power is much more. And you should look into the case unbiasedly, into the dispute unbiasedly. And after looking into the case unbiasedly, maybe with a good lawyer, or I'm just suggesting, or your own people, their company people are also intelligent, they are, but egoistic. When it comes to their case, they will say, I will go up to Supreme Court. So if you do that, then you will lose. But if you take a well informed decision, then the company will not suffer. At the end of the day, that is the idea. Huge interest payments can be avoided. That is my suggestion. Thank you very much. Have a great evening. Bye.